to the length, section by section, and placed before the Senate for final consideration.
You've heard the unanimous consent request. Is there an objection? Hearing none, it is so ordered, and Senator Lodge is recognized to open debate.
Thank you very much, Madam President. Senators, today I bring for your consideration Senate Bill 1309. Last year, the legislature passed, and the gentleman on the second floor signed, the Idaho Heartbeat Law. Shortly after the legislation became law, the state of Texas passed legislation which has withstood numerous court challenges on procedural grounds, which includes a private enforcement mechanism. Senate Bill 1309 updates last year's legislation to include the private enforcement mechanism modeled after the Texas Act, but modified to better withstand legal challenges. This legislation requires abortionists to follow standard medical practices to determine if a fetal heartbeat is present prior to performing an abortion. It establishes civil liability for abortionists performing or inducing an abortion after a preborn baby's heartbeat is detected, excepting in cases of medical emergency, rape, or incest. The section pertaining to state enforcement of criminal penalties would remain ineffective until triggered by a federal appellate court decision upholding the constitutionality of a heartbeat law in another state. Section 8807 creates a civil cause of action for certain family members of the aborted baby to sue for real damages caused by an illegal abortion, but the person who impregnated the mother through the act of rape or incest cannot sue. There will be a traitor bill that will be following this legislation, and I won't go into that at this time, but I would like to talk about the next section, which is continuing on page 4 on numbers 6, 7, and 8, which clarifies that the civil causes of action exist independently of criminal actions. State officials, including state boards of nursing, pharmacy, and medicine, chapters 14, 17, and 18, Title 54, Idaho Code, are barred from enforcing this section, thereby ensuring that this section can only be enforced by private citizens. The Supreme Court has had several opportunities to block enforcement of similar laws in Texas, which they have not done 3 different times. The Supreme Court made it clear when it dismissed the U.S. Justice Department's lawsuit against Texas last December. You cannot sue a state to block enforcement of a law that the state does not enforce. Again, the state is not enforcing the law. It's a private citizens who can file suit. Senators, this gives you an overview of this updated legislation following Senate Bill 1183 of last year. With that, Madam President, debate is open.
Is there further debate?
Madam President.
Senator Stennett.
Thank you, Madam President. Debate against the bill.
Senator has the floor.
Thank you, Madam President. Senators. 1 in 4 women are forced into coerced sexual experience. There is spousal reproductive abuse and intimate partner violence. Yet on page 3, lines 45 and 46 into page 4, lines 1 and 2, the father, married or not, as a partner, even if it's a one-night stand, grandparents, siblings, aunts and uncles, interestingly, not parents, are allowed to criminalize the doctor, even if it's an attempt. There's no definition of attempt. They had a discussion about it. There was even a consideration, but the action didn't happen. And yet each family member can criminalize the doctor up to 4 years after, which is allowing citizens, family members, to police each other. The breadth of family members intruding on a woman's reproduction is far more than any other statute we have for children who are born. 16,000 children are born without parents in Idaho. And do you want your family members meddling in your healthcare decisions? I'm sorry, I like a lot of my family members, but there are several of them that we don't agree on healthcare issues, and I wouldn't want them weighing in on what I should be doing with my own personal health care. It is a double violation of the mother, and it empowers the abuser. According to the Idaho Academy of Family Physicians, Madam President, dated February 16th, may I read? It's a statement on protecting the physician-patient relationship. They support protecting patients and clinicians who provide medically necessary care, prevent private citizens from interfering in other patients' healthcare decisions, provide continued access to evidence-based comprehensive care and information, and protect the integrity of the physician-patient relationship and prevent government overreach and interference into this relationship. Oppose any policies that threaten our patients' ability to make informed decisions on the impact of their health and well-being. I find it pretty surprising that in some instances we want to make sure that we have a government overreach on protecting our ability on vaccinations and masks and all kinds of things, but somehow it's okay to do it here. And the bill bans abortions when it has cardiac activity. We have heard the doctors say this isn't true heartbeat at early ages of 6 weeks or earlier. It is detectable, but it's cardiac activity. Not necessarily a heartbeat, but oftentimes it's before the woman even knows that she's pregnant. And as a side note, with embryonic life, there is unfortunately times when the fetus does not have a heart and therefore has no heartbeat. And like those without lungs or brains or other vital organs that have not developed, they are non-viable and they will die at birth. And we have given them no options to have a consideration about what they will do in those cases. Madam President, thank you.
Is there further debate?
Madam President.
Senator Burgoyne.
Thank you, Madam President. I rise in opposition to the legislation. You have in front of you a copy of an Attorney General's opinion that was responsive to my requests and questions. I intend to go through portions of the Attorney General's opinion. I've highlighted those areas that I plan to discuss for you, if you care to follow along. On page 1 of the Attorney General's opinion, and if I may read, Madam President, this Attorney General's opinion is, now that I look at it, I can't find that it's dated, Madam President. But it did come from the Attorney General's office, and it came to the Attorney General's office a week or so ago.
Okay, having identified the source, the Senator may read.
Thank you, Madam President. And if I can just share with the body, I get the impression that the Attorney General has been pretty busy working with us on taking our requests and responding. And you will also notice that I have interlineated on the pages, the page numbers for the opinion. On the first page, the Attorney General sets out some of the history in response to one of my questions with respect to the abortion issue. And the Attorney General notes the Roe versus Wade decision. And the Attorney General notes that the 1973 Roe versus Wade decision is up for review by the United States Supreme Court. And indeed, there is speculation or even expectation that a decision could be released by the end of June of this year. And I think we all know that there is a widespread view that the Supreme Court may either modify or reverse the Roe versus Wade decision. However, as of today, Roe versus Wade is the law of the land. And I have said this before, and it's a bit mundane of an analogy, but I will draw it nonetheless. To pass legislation such as this today and have it take effect as soon as it becomes law. And if you look at the bill, on the last page of the bill, you'll see the enactment would in section 7 of page 4 of the bill that it will take effect 30 days following signature by the governor. So to pass it today, to have it take effect as soon as the legislature passes it 30 days after being signed by the governor, essentially means that it's going to take effect, if at all, sometime in April or May. And that's a little like passing an infraction statute, saying the infraction statute will take effect on July 1, but police officers get to enforce it in June. We don't do that. It violates very basic tenets of law to do something like that. And while I agree that's a rather mundane situation, and this is much more serious, I think the principle holds. There is no trigger in this legislation. There's nothing that says in this legislation that it will only take effect at such point as it is constitutional. And that would, in my estimation, make a difference. I'd just like to point out for the body that in section 42 of the Mason's Manual, in number 9, it says, decisions must not violate constitutional limitations or judicial decisions interpreting the Constitution. That's the headline for that section of Mason's. And I would submit to all of you that I think if we pass this legislation, we are in violation of that provision, the Mason's Manual. I recognize that others in this body might read the provision differently, but that's how I understand it and what I believe is to be the correct view of that section. Furthermore, beyond Roe versus Wade, there are other potential constitutional issues, and this is on page 2 of the Attorney General's opinion. There are other constitutional issues with respect to this legislation. The Attorney General points out that in the Ninth Circuit Court of Appeals, there can be an equal protection issue when laws unequally burden abortion providers, and those issues are evaluated under the Equal Protection Clause. And quoting now, at the bottom of page 2, in that last paragraph that carries over to the next page, at the beginning of that paragraph, the Attorney General's opinion states, Senate Bill 1309 would create a novel civil enforcement action that authorizes lawsuits against medical providers who knowingly or recklessly attempt, perform, or induce an abortion after a fetal heartbeat is detected. There are significant differences between this civil enforcement action and procedures for other actions that can be brought against medical providers for violation of the other state laws in the provision of care. And then in the next sentence, it begins, for example, and I'm not going to go through all of those examples for you. I'm going to skip over to page 3, where the Attorney General says, beginning on the 3rd line, notes particularly the 4-year statute of limitations, and how the 4-year statute of limitations in this legislation is different than our general statute of limitations for personal injuries and wrongful death in Idaho, which is 2 years, and cites Idaho Code Section 5-219. Indeed, the Attorney General says, enforcement of state laws governing medical professionals solely through the civil enforcement action is itself novel. Medical professionals are required to comply with state laws governing their practice, in large part through the discretionary prosecutorial actions of their licensing boards, which carry their own penalties. But licensing boards would be precluded under Section 6 of Senate Bill 1309 from enforcing the ban on abortions after a fetal heartbeat is detected. based on the significant difference in treatment between other state laws governing the provisions of medical care and the enforcement mechanism in Senate Bill 1309, a reviewing court could conclude that the enforcement mechanism violates the equal protection guarantees of the U.S. and/or Idaho constitutions. Here, I would just like to stop for a moment and say my own personal view is that what is detectable at 6 weeks often is not a fetal heartbeat per se. And I know that there are those who very much disagree with me on that issue, but that is my view. Then the opinion segues into a provision of the Idaho Constitution, and that starts in Part C at the bottom of the text and above the footnote on page 3. And it relates to the fact that our licensing boards are part of the executive branch of government, and we have a constitutional provision regarding the governor and the executive branch of government and their powers. And this section of the Attorney General's opinion discusses how this bill contravenes the constitutional provision. So the headline there is Senate Bill 1309 may be an unconstitutional delegation of the governor's enforcement power to private citizens and violate the separation powers under the Idaho Constitution. That bottom paragraph, which begins on page 3, says the Idaho Constitution vests the supreme executive power of the state in the governor and assigns him the duty of seeing that the laws are faithfully executed. Idaho Constitution, Article 4, Section 4. But Senate Bill 1309 expressly precludes any executive branch officer or employee from enforcing the requirements of the proposed chapter, including licensing agencies, citing Section 6, lines 30 to 36 of the bill. This reallocation of the executive branch's constitutional duty to private citizens could be found to violate Article 4, Section 4 of the Constitution. The delegation of the governor's enforcement power to private citizens could also be found to violate Article 2, Section 1, which expressly states, and the Attorney General has here quoted that particular constitutional provision, departments of government. The powers of the government of this state are divided into 3 distinct departments, the legislative, executive, and judicial. And no person or collection of persons charged with the exercise of powers properly belonging to one of these departments shall exercise any powers properly belonging to either of the others, except as in this Constitution expressly directed or permitted. Skipping now, I'd just like to point out to you in the next paragraph, the final sentence where the Attorney General's opinion states, under the proposed legislation, the legislature arguably would be stripping the executive branch of its constitutional charge in violation of the constitutional separation of powers. Why is that significant? Well, the proponents have been very candid in their hope and belief that the mere passage of this legislation into law will stop abortions in Idaho and set up a Texas situation. And a little bit about the Texas situation is, I think we all know, the Supreme Court used its shadow docket as a way to avoid enjoining the Texas law out of the chute, and the Supreme Court of the United States will take up that at a later time. It drew a rather interesting dissent from Chief Justice Roberts, who noted that this gave states an opportunity under federal Supreme Court procedures to act unconstitutionally for a period of time, which he thought was inappropriate. Here we have as the Attorney General lays out with respect to the governor's powers and the executive branch powers, which the bill removes, if in fact that is unconstitutional, it gives an immediate remedy in the Idaho courts for this legislation. And if our Supreme Court acts relatively quickly, the Idaho Supreme Court may be acting ahead of the federal courts with respect to its own constitutional issues, our own constitutional issues under our own Constitution. So we may not be putting ourselves into a Texas scenario because of some unique provisions in our own Constitution. Further down on page 4, item D in the Attorney General's opinion, it states the statutory damages available under Senate Bill 1309 may violate the U.S. Constitution's Due Process Clause. The Attorney General writes, the Due Process Clause of the 14th Amendment of the U.S. Constitution prohibits the imposition of grossly excessive or arbitrary punishments on a tortfeasor. In other words, someone who commits a civil wrong, which is what this legislation would provide for. On page 5, in the first full paragraph, the Attorney General's opinion states, in analyzing whether Texas's Senate Bill 8's statutory penalty violated the Due Process Clause, the Texas District Court analogized to the constitutional limits the U.S. Supreme Court has found for punitive damages award. And then skipping some, the opinion goes on to say, the court held that the $10,000 minimum statutory penalty authorized by Texas's Senate Bill 8 in civil enforcement actions violated the Due Process Clause, citing the Van Steen decision. A reviewing courts could similarly conclude that the statutory damages of a minimum of $20,000 available under Senate Bill 1309 violates due process, either under the due process analysis specific to statutory damages or by analysis or by analogy to the analysis for punitive damages, because the sizable statutory damages award can be awarded even when the plaintiff suffers no harm. And then in the next paragraph, and I do think this is a rather key point about how the bill is structured, the fact that the statutory damages available under the civil enforcement mechanism start at $20,000 but are not capped at a maximum is of greater concern. There does not appear to be any guidance as to what actual statutory damages awarded should be, other than that they cannot go below $20,000. This alone could be found to violate the Due Process Clause because there is arguably no fair notice of the severity of the penalty that may be imposed, and the lack of a cap facilitates the imposition of an arbitrary penalty. Again, I actually think the Idaho courts are going to have some real difficulty. If any of these cases end up in an Idaho court, they're going to have some real difficulty figuring out, have we got a statutory penalty here, or do we have an actual damages penalty that somebody has to, in order to get more than $20,000, actually prove damages to themselves? And if so, how much? And where does statutory penalties leave off and actual damages begin? It's all pretty confusing. Next, the Attorney General's takes on the issue of standing. And as you know from the structure of the legislation in front of us, various parties are able to bring civil suits, and the issue has been long discussed, and I don't feel I need to go into it here, that when you get relatives involved in a piece of civil litigation like this, the issue of standing is pretty obvious. And at the bottom of page 5, the Attorney General's opinion states, concepts of, and skipping a little bit, standing ensure that cases brought before the court fall within the court's constitutional authority to adjudicate them. Now, this is a really important issue, I think. We hear a lot about activist courts, and we hear a lot about activist judges, and indeed, one of the more serious attacks, I think, on Roe versus Wade has been this idea that the U.S. Supreme Court in 1973 was engaged in judicial activism. And it is the issue of standing that limits courts and that does prevent judicial activism. Beginning at the very bottom of page 5, the opinion states, standing determines whether an injury is adequate to invoke the protection of a judicial decision. And then moving to the last sentence of the next paragraph on page 6, standing is rooted in the party challenging the law having suffered a distinct and palpable injury because of the law, not just being opposed to a law or action or principle. Here, it is difficult to see how a competent adult woman who consented to have an abortion performed upon her can be said to have suffered an injury. And then skipping to the last two sentences of that paragraph, further, the statute does not require the plaintiff relatives to have suffered any mental distress at the loss of the pregnancy to bring the civil action, yet they still would be awarded at least $20,000 in statutory damages. This would be true even if the claimant was personally in favor of the abortion. The related facts that Senate Bill 1309 would grant standing to individuals who may have no injury resulting from the abortion, and that they would be entitled to a large statutory award of damages without any proof of harm, could cause a reviewing court to conclude that the civil enforcement mechanism is either facially unconstitutional or unconstitutional as applied to specific enforcement actions brought under Senate Bill 1309. Here I'd just like to kind of note parenthetically my own view. There is a rape and incest exception in the legislation. However, I don't really think that it's particularly operative in the sense that while the bill bars the rapist himself from suing, his parents or other relatives can still sue. Finally, going to page 9, the final page, and I think we're all glad to be there. Beginning in the second sentence, well, actually it's a clause, the last clause of the first sentence of this first whole paragraph on page 9. Senate Bill 1309 would likely still be vulnerable to pre-enforcement suit. The state of Idaho can be directly sued for violations of the Constitution. An abortion provider could bring an action for a declaratory judgment and injunctive relief in state court under Idaho's Uniform Declaratory Judgment Act in a pre-enforcement suit raising at least some of the constitutional issues discussed above. And I think that's further to the idea that it's unlikely in Idaho that we'll see the kind of delays that are going on with respect to the Texas suit. Then in the next paragraph, the issues with Senate Bill 1309 could also be raised as a defense to a civil enforcement action under SB 1309. Abortion providers in Idaho may be less hesitant to test Senate Bill 1309 in a post-enforcement action in court because it more clearly prohibits discipline by licensing authorities and has greater limitations on the civil enforcement actions compared to Texas SB 8. There is also a possibility the Department of Justice would file a pre-enforcement suit seeking to enjoin 1309, and then skipping to the last paragraph there, I do want to point out, however, it remains an open question whether the Department of Justice can bring such suits. So the Attorney General is not saying that the Department of Justice would necessarily be in a position to do so, but it is possible that the Department of Justice would. In short, it is unlikely that SB 1309 would escape pre-enforcement judicial scrutiny, and it could also be subject to post-enforcement scrutiny. Now, what that sentence means to me, when the Attorney General says it is unlikely that SB 1309 would escape pre-enforcement judicial scrutiny, what that says to me is that plaintiffs seeking to enjoin the enforcement of this legislation once it becomes law could get into court on the afternoon of the day that it becomes law, on the next day, and would have an opportunity to obtain an injunction against the enforcement of the law before it even really had a practical chance to take effect. And that is because of the unique way that it is drafted. One further thought that I have with respect to the legalisms in this legislation is I get the idea. The proponents, I credit them with being very honest with all of us about their intentions. And their intentions were to bring a bill that would put an immediate stop to abortions in Idaho. And while I disagree with them, I respect their candor and their honesty in saying that's what this was designed to do. Indeed, if it does not get enjoined, it may in fact very well do that. They may be correct about that. But the thing about that is that along the way, they just didn't pay, in my estimation, enough attention to the technicalities that are ultimately, probably, in my view, going to be the undoing of this legislation. Finally, Madam President, I'd like to read an email that I received on this issue from Rachel Chisowski, dated February 16, 2022, in reference to this legislation.
Having identified the source, the senator may read.
Thank you, Madam President. Now, I'm going to edit this just a little bit. I'm not going to read the entire email, but she starts off by saying, "My name is Rachel Chisowski. I am a family doctor resident in Boise, District 17, taking care of adult, pediatric, and pregnant patients in the Treasure Valley." Skipping now, Senate Bill 1309 is a dangerous bill that will have potentially devastating consequences for families and individuals in our state. As noted by others, the criteria used in this bill is not medically sound and undercuts Idaho's strong values of personal autonomy. Regardless of personal beliefs, we have evidence that abortion bans lead to increased childhood poverty and maternal mortality, when Idaho already ranks low in the nation for education and services for children. While stories of abortion regret are heartbreaking and highlight the need for more social services to allow people to make whatever choice is right, they are also not the majority. There are multiple well-designed long-term studies that find that the majority of people who have abortions do not regret them, and there is higher regret, mental health conditions, suicidality, that was hard for me to say, and poverty after being forced to carry an unwanted pregnancy. The bill violates privacy. The rape and incest exceptions force a pregnant person to disclose and relive a traumatic experience, both to the law and to a healthcare professional, likely before they are emotionally ready. It also offers abusive partners, family members, a lever to control the life and choice of that patient, also not consistent with Idaho's values of liberty. Particularly chilling to me is the effect on physicians like myself and my colleagues. This places the government, as well as complete strangers, anyone who claims paternity and their family, in between myself and my patient. While the bill is directed toward abortion providers and designed to limit abuse, I fear I still may be targeted. Taking care of pregnant patients means sometimes I take care of unexpected outcomes, such as miscarriage and ectopic pregnancies. I worry that grief and anger following such outcomes or simply greed will open the door for unwanted lawsuits. And then skipping some now. This is unsettling and highly likely to deter physicians from coming to practice in our state. In a state already suffering a severe shortage of primary care physicians, this is a disservice to our population. The bill undermines the physician-patient relationship, and passage of this bill raises concerns for more government interference in medical care based on political rather than healthcare reasons. In a state that prides itself on decreasing restrictions and promoting liberty, and then I'm substituting some of my language here for hers and paraphrasing, this is inconsistent to Idaho's deeply held values. In fact, a 2019 poll shows that 65% of Idaho voters believe a pregnant person should have access to all reproductive care options. I ask you to respect the will of the Idaho people and the doctor-patient relationship and avoid dissuading doctors from coming to our state. Please vote no on SB 1309. Thank you, Rachel Chasowski, Doctor of Osteopathic Medicine. Thank you, Madam President.
Is there further debate?
Madam President.
Senator Grow.
Thank you, Madam President. To debate in favor of the bill.
Senator has the floor.
Thank you. Madam President, fellow legislators, I care deeply about protecting the most basic of all rights, the right to life, especially of our most defenseless, the unborn. Victims of most other horrible evils of our day are not entirely defenseless, as are the unborn. Victims of human trafficking, or of abuse, or of kidnapping, may have the opportunity for escape or for recovery, not the unborn. Ultrasound views show the human fetus as it tries to avoid the instruments that will tear it apart and terminate its life. There is no escape. Because some want to define that fetus as something less than human life, it does not change its nature or its value. If it is not human, what is it? If it is not alive, why does it require outside intervention to terminate it? And since it has its own DNA, its own circulatory system, and often of a different blood type, sex, or even race different from the mother's, it cannot logically be considered the body of the mother. It is my fervent prayer that Roe versus Wade will be corrected through constitutional means. The Supreme Court will have an opportunity to do that within the next few months, 5 months or so, when it considers Mississippi's Dobbs versus Jackson Women's Health Organization case. This proposed Idaho bill is an improved version of the Texas law. That law is successful, whether that law is successful, whether it is legal, the Texas law, is yet to be seen, as the Texas law is subject to further constitutional challenge. As a person deeply and inalterably opposed to abortion, except in a few extreme circumstances that were laid out, but committed to the rule of law, we must weigh the value of the right to life against the possibility that the Supreme Court review will eventually invalidate it. The tentative constitutional status of the Texas law makes it unclear as to what the law of the land really is. Until that decision is finally made, let's take advantage of this opportunity to halt the slaughter of the unborn in Idaho. No matter what the outcome of Mississippi's challenge, between now and the time of that Supreme Court decision, this Idaho bill will potentially deter the abortion of hundreds. No matter what else the issues are, I encourage you to vote with me solidly in favor of the rights of the unborn. I will be voting yes. Thank you, Madam President.
Is there further debate?
Madam President,
Senator Semmeroth.
to vote against, or to debate against the bill.
Senator has the floor.
Good legislation includes the representation of different voices sitting at the table and coming up with a working solution that represents multiple perspectives. This legislation only represents one voice, one strong voice from Texas. It is not an Idaho bill written for Idahoans, representing the voice of different Idahoans. It doesn't represent Idaho, and it surely doesn't represent the hundreds and hundreds of constituents in my district who have contacted me asking me to vote no. As the senator from District 16 very thoroughly pointed out, this legislation presents multiple constitutional violations, which will undoubtedly require the payment for legal fees when it goes through litigation. Idaho has already spent over $1 million for abortion lawsuits, and it's likely to see another lawsuit if this bill passes. Additionally, there's nothing in place to stop frivolous or malicious lawsuits against providers. This Texas bill does not belong in Idaho. I urge you to vote no.
Is there further debate? Hearing none, Senator Lodge is recognized. Excuse me, Senator Patrick.
Sorry, Madam President, I didn't stand up quick enough or tall enough to debate the bill.
The senator has the floor.
What I'd like to bring up is I get a lot of controversial bills in my committee and a lot of correspondence. However, this bill, I've had a lot of calls only from my district saying we don't like it. So now we're going into an election period. I don't like abortion. We're going to have a Supreme Court ruling from the federal government, and we got some time. That's soon. So if we'd have to remodel this if they're depending on the ruling. But I think we should wait and see what the ruling is. I think this is a little bit too quick. And so I'm going to lose either way because of how I vote here today, because it's really divided out in the country. With that, that's all I have.
Is there further debate?
Madam President.
Senator Wintrow.
Thank you, Madam President, to debate against the bill.
Senator has the floor.
I really appreciate the senator from 25, his remarks today, because I've brought some of that legislation to increase access, because I think it makes the best sense to keep us from talking about the things that we're talking about today. Yet it was still tough to get it through this body. You know, we are at a crisis point in our history when it comes to this issue for reproductive health care and the rights that people have to their own bodies. This feels like a very aggressive attempt to continue to just shatter the rights that we have nationwide. It treats women, this bill treats women as if we're children, and a husband or family member or even parents of a rapist now controls their choices with threats of bounty systems, mandating somebody carry a pregnancy to term, even against their will. I think, you know, in the last 2 years, we've heard a lot of discussion about mandates in the legislature and just overwhelmed our states fighting about not mandating just a little piece of cloth on our face to fight a virus, yet we're willing to mandate somebody carry a pregnancy against their will. I'm at a loss with that. The bill uses, it's been referenced, false language about fetal heartbeat, and the intent of the legislation really takes a position in that life begins at fertilization. If this body believes that a grouping of cells, 6 weeks, basically at 6 weeks, a grouping of cells is about the size of the tip of my finger, there is no fetal heartbeat detected at that point. There might be cellular activity that's detected with a very invasive transvaginal ultrasound, which is about 1 foot long, put inside a person's vagina. That's when you can detect it. Pretty invasive. And if we're going to say that that constitutes a child, an unborn child, then I would ask serious questions about parent rights. And what about the rights of the person carrying that embryo? I did a quick search, and in fact, I have 17 laws that deal with parental rights. And that was a quick search. And dealing with not only the control and care of the child, but as I quote in the Parent-Child, the Idaho Rights Act, the actual destiny, and I quote, of the child. The destiny. And these bills cover everything from controlling immunization, education, marriage, even to the basic denial of medical treatment of a child based on sincerely held religious beliefs. Allowing a child to actually die if somebody comes forward and says it is their destiny. Now, there's many carve-outs in Idaho law for sincerely held religious beliefs. And I'd like to ask where the carve-out is for this one. If somebody had a sincerely held religious belief that is different than the dominant culture of the legislature, where is there room for their belief? I heard citizens in this building talk about God coming to them and them sincerely believing that they should not get a vaccination. And so I'm wondering why those voices might be more important than this voice. What if somebody said, God came to me, spoke to me. This is my sincerely held religious belief about destiny. Are we going to allow for that carve out here? It doesn't appear so. This bill, modeled off of Texas abortions bill, it allows vigilantes to sue doctors and health centers who provide abortion care after 6 weeks, well before many people know they're pregnant. We've already covered that. This vigilante approach is an attempt to make an end around the constitutional right of abortion, which remains the law of the land. And this bill would eliminate abortion care in all the state of Idaho. And it's really pretty hard already to get an abortion in Idaho. Our health care, our rights, and our freedom are on the line like never before. People in Idaho should have access to health care without government interference in our personal private decisions. I've received closing in on 500 emails from folks to tell me to oppose this bill, all from my district, just mine. I can't imagine if we put them all together, which I do think underscores the senator from 16 when he quoted the statistics that 65% of Idahoans still believe that women should have right to and access to health care, reproductive health care, which includes legal access and access to legal abortion. No one's personal medical decisions should be interfered with in this way. I'm going to focus really on an area that you know is very near and dear to me. And that's the aspect of the bill that does not really provide meaningful exceptions for survivors of rape or incest. The bill says it does. You have to provide a police report. But according to 74-105 Idaho Code, those police reports are protected. They are exempt from public disclosure. Police will not give those reports during an active investigation. And according to the Idaho State Police report on their website, the average time from report investigation ending is about 3 months. And so if somebody were going to get a police report, on average, it would take 3 months to get it until that investigation wasn't active. And now, if it's still active, the prosecuting attorneys aren't going to release it either because it's going to harm their case. So I really want to emphasize, I don't think there is a legitimate legal exception here for rape or incest or abuse. I want to give you an example. You know, I feel like in this body, you know, this nice, pretty, sterile environment, we talk a lot about ideology, we make remarks about philosophies, we try to thread the needle of the law, but we sometimes forget the real lives and the real scenarios that people are going through. And life is complex. It's more than a line in the sand. And I want to share with you what this bill would do to somebody that I worked with. One of the last people I helped when I was at the Women's Center was a student who was in an abusive marriage. And she would drive her husband to class and go by the Women's Center. And finally one day she got the courage, after she dropped him off, to come inside. And I worked with her for months. I consulted with the Women's and Children's Alliance to try to help her find her way, create a safety plan, and to figure out what she was going to do with her life. And finally, 3 months later, I got a call that she said, Melissa, I'm ready to escape. I called the sheriff, I called the Women's and Children's Alliance, I met her at her apartment. Her husband was at class. Why did she choose to escape at that moment? Because she overheard her husband and mother-in-law planning her kidnapping and rape because she didn't want to have kids. That's the kind of people we're talking about here on the other side of this bill. And this bill would have provided a potential avenue for an abuser to actually mother-in-law to make a suit against a doctor if she chose to get an abortion, if she could have gotten out of the kidnap situation, clearly. I had another constituent contact me recently and talk about her story as a child when she was just getting her period. Her father raped her. She didn't know what to do. And her mom was in the hospital. She didn't know who to tell. She was ashamed. She thought she had done something wrong. Her father said, do not tell a soul. Do you think she's going to get a police report? Do you think she's going to get an abortion? She's going to be forced to carry that to term. These are the kind of complex situations we're talking about. These are the real lives of people that are on the stake. These are the things that make my heart drop and my stomach turn when I see these bills come about. And I don't think any of us even think about those ugly, ugly things. But I can tell you when I worked with survivors of assault and domestic violence, I saw the underbelly. I saw really awful, violent, evil things. And this bill would continue to put red tape and bureaucracy on people who are in trauma, who are struggling to find their way in life. On top of that, regardless of abuse, regardless of incest, regardless of rape and violence, the bill itself feels violent to me. It feels like an attack on me as a human being, able and capable of my own moral decisions about my body. Now a government agency, the whole state of Idaho, enabling my family to come after me if I make a choice. I mean, when the bill sponsor read the bill out loud, I just sat here thinking, gosh, that is the most awful things I've ever heard. To turn neighbor, I guess family member against family member in the cause of an ideological stand. I think this bill is unconstitutional. I think we will be in a court. I think we will have a lawsuit. I think we'll pay, more taxpayer dollars to fight it. I don't see the need and urgency to copycat other states. And again, just the ugliness of doing this and not thinking about fully all the implications it has on people who are suffering.
Is there further debate?
Madam President,
Senator Ward Engelking.
there's not much more I could add to what the good senator from 19 said, but I do want to say this. In my 33 years of teaching, 6th grade and junior high, I had 3 students pregnant at 12. Think about that. Think about what this would mean to them and to their lives.
Is there further debate? Senator Zito.
Thank you, Madam President. I kind of consider myself a little bit of an expert when it comes to babies. I've had 5 and I've got grandchildren. And I just want to say that it grieves my soul greatly when I hear God's greatest creation, which is his children, referred to as a clump of cells. And I don't care what stage of development that is. A life is a life. And it's our greatest obligation as legislators to protect those lives who cannot protect themselves. Now, life isn't perfect. It can be ugly, and it can be dirty, and it can be brutal, and it can be vicious. But the greatest beauty and the greatest glory is that of human life. And for us to protect that and to watch out for those babies is the greatest thing that we can do. Thank you, Madam President.
Further debate.
Madam President.
Senator Blair.
In favor.
Senator has the floor.
Thank you. I appreciate the debate that has gone on here, and I'll try not to drone on. But life isn't always black and white. It's not always clear. And I am a child of the 60s, born during a time of great divisiveness in our country and in the world. And if you're walking into the sunshine, the shadows of that seems to still be following me, and that divisiveness also follows our country. But I think I bring a very unique perspective to this issue. I am adopted. And if it was not for my mother's decision not to have an abortion, I would not be here. And we are here today as a body to be that voice, to be the voice of those that cannot speak. And I wonder what my parents, who graciously adopted me, would have done if I wasn't there. Where would my wife be today? Where would my 2 boys be today if my birth mother decided to have an abortion? We've heard good debate. I appreciate the sentiments of the senator from 14 and from 23. We are that voice. We are that voice for those that are unborn, like I was, that have been given that chance to have a life. With that, Madam President, thank you.
Is there further debate?
Madam President.
For what purpose does the senator rise?
Madam President, to debate for the second time.
Is there any senator who wishes to debate for the first time?
Madam President.
Senator Ricks.
To debate the bill in favor.
The senator has the floor.
Good senators, I debated whether to stand up or not here, but I feel strongly about this issue, and I feel strongly for life. I have studied a little bit about some of our ancient civilizations, some of the customs that they had, and it's quite alarming that some of the earlier civilizations actually killed some of the children. And it's very alarming. The Canaanites sacrificed their sons and daughters unto devils, and they shed innocent blood. Manasseh carried on some of those traditions in the Jewish tradition and introduced that custom and sacrificed children to a god called Moloch, and set the example by offering his own children. The Persians, among the ancient Persians, it was common custom to bury children alive. In some Grecian states, infanticide was not merely permitted, but it was actually enforced by law. The Spartan lawgivers expressly ordained that every child that was born should be examined by the ancient men of the tribe, and that if found weak or disformed, they should be thrown into a deep cavern at the foot of a mountain. And there's other civilizations that's done that. The Romans, they were the most unrelenting in their treatment of infants. Romulus obligated the citizens to bring up their male children and the eldest of the females, proof that the others were destroyed. I wonder how our society is going to be remembered by those who come after us in generations. How are they going to look back at us and what we did with the most innocent of life? I have to stand and support this. I think we need to look at life and respect it as being precious and give these little ones a chance. They have every right, every right to enjoy the freedoms and the right to life that we all enjoy today. So I support this. Thank you.
Is there further debate? For the first time, Senator Wintrow.
Madam President, a debate for the second time.
The senator has the floor.
Madam President and Senators, just very quickly, I appreciate all the debate and I appreciate everybody sharing their personal beliefs. I think that's really important. What's most important is that the government does not take on one set of beliefs over the other. And in this case, my religious beliefs are being infringed upon by the dominant religious belief. Not everyone believes that life begins at conception. Some believe that life begins at first breath. And some believe the life on the planet who is the adult actually has precedent and has rights too. What about my life, my rights as an adult woman caring about my business in this world? Because I can tell you, it's not always a free choice to have sex. People are coerced, begged, bartered, shoved, pushed, threatened all the time.
What I didn't say is that Timothy.
What about my rights? And I really appreciate the good senator's reflection of history and wondering how we will be remembered. And on the flip side, I ask myself that question, how will we be remembered? Will we be remembered like the novel The Handmaid's Tale, with all the women in their red dresses being treated as vessels just to carry babies against their will? I hope not. Because we have to look at the rights of the person in front of you and not totally diminish my rights in this as well. And I think the constitutional right that I have currently, the government, the courts, they made a good decision that has stuck for 50 years. And I would ask us to respect that and to respect all rights. Thank you, Madam President.
Is there further debate? Hearing none, Senator Lodge is recognized to close debate.
Thank you, Madam President, and thank all the good senators who spoke today. There's quite a list, and you know, life is tough. And my dad used to tell me when I was young, just remember that life is tough. And I've tried to take that throughout my life when I've talked to other kids and other people about what their rights are and what the rights of someone else is. You know, I've mentioned it before that when I had my children, there wasn't very much technology available. But today, the medical advancements in technology have brought us so far. And when I saw my daughter's twins on the ultrasound at about 8 weeks, I was amazed, and it just changed my whole point of view on is this little embryo really life? And when I saw that baby, those babies moving around, it was an unbelievable experience. When they were 15 weeks old, and I saw an ultrasound again, Juliana was sucking her thumb, and her brother was there just watching her, just there. And to watch that development of that small embryo into that child and see those children today at 7 years of age is such a miracle. And it's so fragile. It's so fragile. Because after that, about a year, 2 years ago, that same daughter lost a baby at 15 weeks. And the whole family is still grieving over the loss of that baby. Does the baby have the same right as the mother? Most of us believe that it does. Because it's not convenient or wanted at that time, there are so many services available to help. When I was young, there weren't any services available. and you were sent away someplace, and the baby was given up for adoption, and you lost total contact with that child. Today in our family, we have open adoptions. And these children have brought such joy to our lives. Good senators, it is human nature to protect those who cannot speak for themselves. Our unborn babies deserve more. They deserve more after they're born, and we need to be doing more. The resources for women and families and for unplanned pregnancies are a multitude in this state. And the services go clear up to 18 months or more. There are people who are establishing homes for these women to go to so they can continue to work, they can continue to go to school, they continue on with their lives. And when you talk to someone who has kept their baby or given their baby for adoption and have kept in contact with that baby, they are joyful over seeing how that child has progressed. Our unborn babies deserve more. They are our future. They are human life, no matter how small they are. They are entitled to their life, the liberty to become who they want to be, and the opportunity to pursue happiness. And with that, Madam President, debate is closed.
Madam President.
Senator Anthony.
Ask unanimous consent the Senate go to ease subject to call the President.
Without objection, the Senate will go to ease.
What's going on?
prior to going at ease, the Senate was at the 13th order of business. Debate being closed, the question is, shall Senate Bill number 1309 pass the Senate? Oh, excuse me, the Secretary will call the roll.
Agenbrod, Anthon, Bayer, Blair, Burgoyne, Burtonshaw, Cook, Crabtree, Den Hartog, Groh, Guthrie, Harris, Hyder, Lakey, Lee, Lent, Lodge, Martin, Nelson, Nye, Patrick, Rice, Ricks, Riggs, Semmeroth, Souza, Stennett, Fain, Van Orden, Vick, Ordingle-King, Winder, Winthrop, Woodward, Zito, Nelson, Woodward,
Roll call shows 28 ayes, 6 nays, 1 absent and excused. A majority having voted in the affirmative, Senate Bill number 1309 is passed the Senate. Is there a correction to the title? Hearing none, the title is also approved, and Senate Bill 1309 will be transmitted to the House of Representatives.